कौन ऑफेंस एतरे कौन अछि
306 my lord.
किते मासे हे गेलानी 24/11
Death of the deceased
हाँ
man.
आउ कौन किछ करियोन दिस कैन नॉट बी अ ग्राउंड आई हैव टू जस्टिफाई माय ऑर्डर
Totally family is a sorrowful situation, my lord.
obviously
No one to look after the
sir can he go out of the jail to look after the family that I have to observe how much time I can grant you 5 days 10 days
ma'am.
looking after the family somebody whose freedom has been curtailed by due process of law can he take the plea of looking after the family
Only the mother is there, my lord.
you should have moved the court
And the case is, my lord, there is no dying declaration and suicidal note.
sir I am not trial judge I am not the trial judge you are seeking interim bail on the ground of somebody dying on 24/11 I have to pass an order
Situation not permit, my lord.
Sorry?
On that time, a situation not permit, my lord. The petitioner's mother not come to the file the affidavit, my lord.
Nothing can be done. That cannot be a ground since the petitioner's mother could not come to court for seeking bail or something. Can that be a ground for granting interim bail? It can be only on merit.
Short period, my lord. Bail
5 दिन 6 दिन काहे की? Why this? You see you create more hope than it should be. He's a under trial. He's now concerned about his family.
Under trial prisoner, man.
Yes.
Chances of I have last resort honorable director to.
That is not a. You show me a decision where chances of acquittal will be a ground for granting bail.
Not that.
You see, I'm trying to learn also along with you. Every day I'm begging. I'm begging I've gone to the extent of begging that come up with some law points. This cannot be a drawing room discussion. बहुत दुख रे अछंती, बहुत असुविधा रे अछंती. He is under trial after following due process. Somebody has lost his life.
For short period, in the interest of justice.
Interest of justice will not be sought if I observe that. I'm asking you. It is your duty. It is your duty. Then why not? Why not the petition? Why not the person whose relation died 2 months back, 3 months back, 4 months back? This is not done. आपण मिनिमम पीरियड केते दिन जिबे कोंतु
to 20 days.
कौन करियो 20 days रे what a order can be passed what obsequies is left after 20 days already you see even I have been requesting you to file the IA you did not file last day it was not filed
we are ready for file but the petitioner the mother is not come
sir somebody not filing a petition cannot be a ground mentioned in the order. You must read the orders, what has been passed, the strictures passed by Supreme Court and others, which is law of the land. No. This casual approach of granting bail, and you must know the consequence of granting bail, what has happened recently.
I am not going on merit, my lord.
But the problem is that you have no merit as far as interim bail is concerned. You must have thought about it.
Minor boy is dead, my lord. Is the appropriate. No one to look after the mother of the person.
So can he go and look after the mother? But that I have to observe, na? Since no one is there to look after the mother, let him go out in interim bail to look after the mother.
For short period, my lord, the new year is
no. After 20 days, it's out of question. Either you withdraw or I'll dismiss it.
I am pray for 6 months.
You can pray for 6 years. That's not a point. That is no difficult in praying for 6 years interim bail or bail. 6 months interim bail, have you ever seen?
I have prayed, my lord.
No, exactly. So have you ever seen somebody getting after being accused and in under trial in 306 getting 6 months interim bail? So that is, you can pray. That's not a problem. That's not a problem.
No mother is there.
The IA number 1625 of 2024.
1625.
2024. IC 1625 of 2024. Flag X देखिए. ଆପଣ ଆପଣ କୋଉଟା ଦଉଛନ୍ତି ତାହେଲେ ଆପଣ ଆ ପରେ ନେବେ The petitioner seeks for interim bail for a period of 6 months on the ground of ये आपण थरे किछ लेखा हैनी ये बिरु किए कौन कार रिलेशन ये आपण भी बढ़िया एंट्री इंस्ट्रक्शन देइचंती आपण पढु नांती कि मनोज दिगल रा पिटिशन बोली बिरु दिगल माने कोर्ट कोन कोर्ट इज रिलेटेड टू मनोज एंड बिरु I don't understand this or the law the AGA is related to Manoj and Biru see you will certify that Manoj is related to Biru
My lord, actually, she had
phone re sang sang lekhi ke anantu this is not done sir I am being indulgent that doesn't mean that you go to any extent you are mane you have provided instruction you don't describe anything how Manoj and Biru are related who are they you will not take obtain instruction that is to be asked phone ne ani ke ebe diyantu see Mr. Swai if anything you can find relating this petitioner with the Biru
My lord, Biru Digal is the son of Manoj Digal, is mentioned here.
ଲେଖା ହେଇଛି ଦିଅନ୍ତୁ ଆପଣଙ୍କ ପାଖରେ କପି ଅଛି ନା ନାଇଁ ଆଚ୍ଛା ସେଟା କହୁନାହାନ୍ତି ମୁଁ ଆପଣ ଯେତେବେଳେ ଫେରଉଛି ମୁଁ ହେଲେ ଆପଣଙ୍କ ପାଖରେ ନାହିଁ ବୋଲି କପି
My lord, he has given one instruction where this status report has everything has not been mentioned. So I immediately
whatever it may be you have given the duty to ask the IO he has to respond to you and in such scenario he has to give you in immediately if they are not responding to the High Court then that is not a good thing
they are responding.
death of his son अरे कुआडे अन्य मनस्क कोन
Yes, my lord. Death of the son of the petitioner.
Mr. T.K. Sahu for the petitioner, Mr. T.K. Das for the AGA for the state. The in response to the prayer of the petitioner, the learned AGA has obtained instructions from the concerned PS. Copy of which is provided and kept on record. Instruction जो लिख लेनी instruction by letter dated 24/12/2024 दी सप्ताह जिबे सरेंडर करिवे दी सप्ताह परे the instruction obtained by the learned AGA indicates that one Biru Digal into bracket 17 son of the petitioner upon a son lekhi nahanti I am taking the risk trusting you
yes
Are you never know yesterday you have seen what happened because the relation filed an affidavit that case is going on and on and on
my lord we have followed the things in the court
you must understand what is happening
my lord
you never know what is there so do you take the proper ye kon lekhle unfortunately passed away in while staying in OUAT hostel, Unit 6 PS Khandagiri. That has been registered as Khandagiri PS UD case number 310 of 25/11/2024. Taking a sympathetic view, the petitioner is directed to be released on bail, on interim bail, under stringent terms and conditions that would be imposed by the learned court in session of the matter, to ensure his presence within the jurisdiction of the police station where he is staying, and he surrendering back before the learned court after a period of 3 weeks from the date of release from the jail custody. আজি কেতে তারিখ আজি হচ্ছে
24,
24
11, 12.
ଏବେ লোয়ার কোর্ট ওয়ার্কিং ডে কোন দিন আছে 26-27 ওয়ার্কিং ডে ଅଛି 25 ବୋଧେ লোয়ার কোর্ট ছুটি ଥାଏ କି ବାହାର କରେ
High. 20.
1 2
Last working day.
Petition 17 1/2024 2025. The petitioner shall surrender on 19/1/2025. The surrender certificate shall be produced ଆପଣ ଯେମିତି ଭାବରେ ଆପ୍ରୋଚ କରୁଛନ୍ତି this will not work out. I8 ଫାଇଲ କରିବା ପାଇଁ ଆପଣଙ୍କୁ ଲାଗିଗଲା ମାସେ, ବର୍ତ୍ତମାନ ବେଲ୍ ଅର୍ଡର ନେବେ ତାଙ୍କୁ ରିଲିଜ କରିବାକୁ ଲାଗିଯିବ ଆଉ ମାସେ। So ନାଇଁ ଶୁଣନ୍ତୁ, I understand ଆପଣ difficulty ଅଛି, but this is not the way the legal process goes on. That who else will understand? Now the order I have dictated, who else will understand apart from you? A client तो बहुत कथा कहिबे, but there is a legal process.
Problem.
सरेंडर बाय 19 बाय कर देबे, काने सेटा 3 सप्ताह हेई पारे नहि पाता पूर्व भी पड़ जाई पारे। ମୁଁ ତାକୁ adjust date ଫେଟ ଆଉ ଥରେ ଚେକ୍ କରିଦେ, calculation କରିକି ହଉନି କି 3 ସପ୍ତାହ ଆପଣ, କାନେ ଏବେ ଆମେ 26 ରେ ଅଛେ, ଏଇ ସପ୍ତାହରେ ଗୋଟେ ୱିକ୍ ଅଛି, ଆର ସପ୍ତାହଟା ଗୋଟେ ୱିକ୍, ହଁ मोर देन 3 वीक्स होची। बाय 19 कर देबे, ठीक अछि। बाय 19 on completion of a period of 3 weeks.
Item 2.
Well, kindly taken up after vacation. Man. Item 2.
Mr. Barik,
Aye.
Mr. B. Barik for the petitioner, Mr. तेरे state party नाहंती, ना अछंती।
Nice state part. Agreed को।
Petitioner opposite party blank. The learned counsel for the petitioner seeks accommodation. Stop. As prayed for, the matter stands adjourned with liberty to mention for listing before the assigned bench.
Item 3.
Obliged.
ଆପଣଙ୍କର ଦିଟା କ୍ୟାଲେଣ୍ଡର ଜୁଡିସିଆଲ କ୍ୟାଲେଣ୍ଡର ଲଗେଇ ଦେବେ ସେପଟେ ଯେମିତି ଲାଗିଛି। ନ୍ୟୁ ଇୟର ହଉ, ଆପଣଙ୍କ ଡିସେମ୍ବରକୁ ପଚାରିବେନି ନା କଣ? ଓ ଆଜି ସରିଗଲା ପରେ, ଆଚ୍ଛା ଆଚ୍ଛା ଠିକ ଅଛି।
ତିନିଟା ମାଇଲା ଆର୍ଜନ ଅନ୍ ବିହାଫ୍ ମିଷ୍ଟର
ତାହେଲେ ତା ତଳକୁ ରଖିଦେଇଥିବେ। ଆଜ୍ଞା,
ଆଇ ପ୍ରେଫର ଆର୍ଜନ ଅନ୍ ବିହାଫ୍ ମିଷ୍ଟର ପିକେ ମହାପାତ୍ର।
ତାହେଲେ ତମକୁ ଖୋଜିଲି ବୋଲି ଆସିଲେନି ଆଜି। ୟୁ ଆର୍ ମିଷ୍ଟର
ଏସ୍କେ ନାଥ।
ଏସ୍କେ ଦାସ।
ଏସ୍କେ ନାଥ।
Mr. S.K. Nath, on behalf of P.K. Mahapatra for the petitioner. Mr. T.K. Das, AGA for the state opposite parties. For the opposite parties, learned counsel for the same order as 2. Yes, next please.
Item 4.
5 also.
5 also.
हाँ 5, 11, 12,
5,
11, 12,
11, 12.
14, 22.
3,
After vacation.
3, 5, 11, 12, 14, 22.
22.
ठीक अच्छे गोटे सेकंड मिस्टर दास आपनकर को जाय अछि
5
5 जाय आपण तले 5 मिस्टर टीके दास 11 मिस्टर यूसी बेहुरा जी 11 12 12 मिस्टर यूसी बेहुरा जी 14 आपण टिके एजीएम कहबे नी यूसी बेहुरा जी तापरे
15
14.
15 UC
22.
22 ना 15 पर कहले
15.
14 कहले तो 22 मिस्टर एसएन नायक एससी
Obliged.
yes please yes
Item
Ms. Mahapatra
My lord, this is a matter where the petitioner is employed in a gram panchayat.
yes
So that gram panchayat has been upgraded to NAC, my lord.
yes
And because of that, now from 97, he is working in that NAC without any regularization or anything. That is an, my lord, that NAC is Noyagad NAC. And my lord, kindly see that they have already, that is Annexure 7, page 16. They are now treating them as DLR. Bhattakrishna Jena, Dhamnagar NAC. Sorry.
yes please yes
My lord, my lord, page 14.
you seek a prayer for regularization under the NAC
Under the NAC, because I am a Gram Panchayat employee. I am not a DLR by the NAC. When Gram Panchayat,
Mr. Ms. Saraswati Mahapatra for the petitioner, Mr. TK Das AGA for the state, hard learned counsel for the petitioner. The petitioner is aggrieved by his continuation as DLR, a DLR under the Dhamnagar NAC. Though he is continuing since 1997, starting with the Gram Panchayat. Subsequently, his job was transferred to the NAC. It is submitted that though he is a regular, though he has been a regular employee under the Gram Panchayat, subsequent thereto, he has been treated arbitrarily by terming his employment as daily labor rated without any rhyme or reason. Issue notice. Para. Sub para kar lekho issue notice, then sub para. The learned AGA appears on behalf of opposite parties, appears and waives notice on behalf of, appears. Learned AGA appears on advance notice, waives notice on behalf of opposite parties 1 and 2. Let 2 extra copies be served on the learned AGA. How much time, Ms. Mahapatra? 3 working days or more? Within 5 working days?
and
Say
opinion
जो
of 3 will
ऊपर लिख लेनी
extra.
issue notice along with this order कर दियो. Issue notice along with this order. Then sapara notice be issued to the OP number 3 by registered post oblique speed post with AD. से रणपुर NAC रे अछंती ना धामनगर NAC रे अछंती
Now, Dhamnagar Gram Panchayat merged with Ranpur NAC. Dhamnagar,
अच्छा there is a Dhamnagar in Noyagad also.
Noyagad also.
Oh, that created the confusion.
Ranpur,
Achha.
Ranpur.
Because somehow I am the local of both the places. So that is not-
That's it.
yes.
30 years back.
Not exactly Ranpur, of course, not exactly, but nearby.
Acha.
Yes. How much time?
2 weeks.
The learned AGA 3 weeks time to obtain instruction and file counter. The opposite party number 3 shall also file their response on their appearance. Copy of the counter shall be served on the learned counsel appearing for the petitioner. Stop petitioner shall have the liberty to file rejoinder. List after pleadings are complete. Stop. Liberty to mention.
Item 5,
Liberty to mention for listing before the assignment is complete कर दियो sentence टा. 5 टा Mr. Prafullo Kumar तंग नाम से कौन कोई गले? SK Nath.
SK Nath.
Mr. SK Nath on behalf of Prafullo Kumar Mahapatra. Mr. TK Das, AGA for the state. Prayer for adjournment is sought for by the learned counsel for the petitioner. As prayed for, the matter stands adjourned with liberty to mention for listing before the assigned bench.
Item 6,
Mr. Samal, Mr. UK Samal for the petitioner.
Disciplinary proceeding
Yes.
initiated against the petitioner who was an officer of the Mahanadi Coalfield Limited.
Yes.
The order of dismissal from service has been passed by the authority who is not competent, who is not the disciplinary authority. Is the main ground here.
When
The
such a mistake they could commit.
Yes. I will
Take
your
notice. Should I record that or let us wait for the response?
Let us wait for the response.
Okay, because I usually observe regarding certain regarding merits why the court is admitting. Usually, as you have marked the last
Right,
case.
right.
The Mr. UK Samal लिखिए, opposite party blank लिखिए. Hard learned counsel for the petitioner. The petitioner is agreed by dismissal from by imposition of a major punishment, major penalty. Proceeding initiated under Rule 30 of the Coal India Executives SR pore apostrophe. So that executives conduct, comma discipline and appeal rules. देखिए लिख परिवे 109 रे अछि. 109 रे अछि.
Also the appeal order.
By कौन लिखले? Sorry, sentence मैं मिस कर ली. Imposition of major penalty of dismissal from service. Yes. The said order of dismissal was confirmed by the appellate authority.
Yes.
The said order of dismissal has been confirmed by the appellate authority. It is submitted by the learned counsel for the petitioner that the proceeding as well as the imposition of penalty is vitiated, being not in conformity with law, apart from several other irregularities. Issue notice by registered post / speed post to the opposite parties. Stop requisites for issuance of notice be filed within 7 working days. The opposite parties shall have the liberty to file their response in response to the writ petition on their appearance. The counter, if any, that would be filed shall be served on the learned counsel for the petitioner. The petitioner shall have the liberty to file rejoinder. Stop. Then lekhantu list after pleadings are complete. Stop. List after. Sorry, liberty to mention for listing before the assigned bench.
7,
Miss Rasmita Singh for the petitioner.
Rita Singh.
I'm sorry, Rita Singh for the petitioner. Don't mind. Rita Singh for the petitioner. Mr. Aurobindo Mahanti for the opposite party. The learned counsel for the petitioner files memo of date indicating that the petitioner seeks leave to withdraw the writ petition. Para. The learned counsel for the opposite party submits that he has filed his appearance as well as affidavit on behalf of the opposite party. But in all fairness, he will not object to withdrawal of the writ petition. Having heard the learned counsel for the parties, the writ petition is permitted to be withdrawn and stands disposed of as withdrawn. The memo of date shall be taken on record.
Obliged.
The petitioner,
Mr. D.K. Sahu for the petitioner. Mr. S.K. Swai, AGA for the state. Yes, Mr. Sahu?
my lord, this is a pension, family pension case.
Yes.
The petitioner father was working at while he was working as such, he was died in the year 2018. Prior to that, my lord, the petitioner was married in the year 2002, and after 10 years, there was a dispute between the wife and husband, and as a result of which she filed a divorce petition before the district judge, and which was decided in the year 22, my lord. My lord, they rejected my claim of family pension under Annexure 8 on the ground that thereafter in the year 2023, there is a circular where the widow divorce daughter are not entitled for pension, family pension. That is under Annexure 20. I am challenging that. Sorry,
Divorced daughter.
divorce.
Divorced daughter to paiba katha.
2000, as per 2011 circular, petitioner is entitled, my lord. Subsequently, in the year 2023, they have mentioned that she is not entitled. Page 23, Annexure 8. And petitioner is only daughter, my lord. As per legal here, she is only.
ଆପଣ ଟିକେ ସେ ଯୋଉ circular ଗୁଡାକ ଦେଇଥାନ୍ତେ ନା
2011 circular.
ସବୁଗୁଡାକ ଆପଣ enclosure କରିଥାନ୍ତେ so that actually it helps the petitioner in the sense that they would be sure what instruction they have to obtain.
My lord.
Because
Subsequently, I have collected the
divorce of the wife. ଆପଣ ଯେତେବେଳେ ଆରମ୍ଭ କଲେ I thought that wife. You ended up in saying daughter.
daughter.
So daughter ର marital status ଯଦି divorce ହେଲା ତାହେଲେ ମିଳିବନି କାହିଁକି ମୁଁ ବି ବୁଝିପାରୁନି ତ circular ନାହିଁ ବୁଝିବା ପାଇଁ. Anyway, I understand, but notice new.
On the date of death, she must be a divorced wife or unmarried wife, unmarried daughter.
Daughter, wife ହେଲେ ହବନି.
No, sorry. Divorced daughter.
Because I think
Divorced daughter must be a dependent at the time of death of the employee.
That was
but ଆପଣଙ୍କର ଆଙ୍କର death ହଉଛି ସେ 2020
18
So
divorce ହେଲେ 2022 ରେ.
ତ ତାମାନେ she was entitled for 18 ରୁ 22 ତାପରେ 23 ରେ ଆସିଲା ଆପଣଙ୍କ ନୂଆ circular. What Mr. Sahoo is saying,
she was not during the lifetime of the father, she was not a dependent. During the lifetime, she was not a dependent. unless she is a dependent.
ମାନେ 18 ରେ ସେ ଚାଲିଗଲେ 22 ରେ ଇଏ ଡିଭୋର୍ସ ହେଲା.
Divorce.
Yes, Mr. Sahu.
Yes, ma'am.
Anyway, take notice.
ସେ ସର୍କୁଲାରଟାକୁ ଆକ୍ସେପ୍ଟ କରିନାହାନ୍ତି, ଆପଣ ଇଣ୍ଟରପ୍ରିଟ କଲେ ଯାହା ହବ.
ନାଇଁ ସେ କହୁଛନ୍ତି ପୁରୁଣା ସର୍କୁଲାର ରେ ପାଇଥାନ୍ତେ.
2011.
Only the surviving case, surviving argument would be
ହଁ.
that if she was entitled on the on the date of her divorce, on the date of her divorce, if she was entitled, then the subsequent change in
ନା,
circumstances of circular, କାରଣ 22 ରେ ସେ ପାଇଥାନ୍ତେ, 22 ରେ ଯଦି ପାଇଥାନ୍ତେ ସେ ସର୍କୁଲାର ଅନୁସାରେ
2011 circular.
22 ପାଇ ନଥାନ୍ତେ.
ନା ଅଛି ଏଟା circular.
ଆଗରୁ ଯୋଉ ସର୍କୁଲାରଟା ଥିଲା ସେଥିରେ ଥିଲା ଯେ ଡିଭୋର୍ସ ଡଟର ପାଇବେ ବୋଲି ଥିଲା ସେଥିରେ. ଡିଭୋର୍ସ ଡଟର ପାଇବେ ନାହିଁ, ଡିଭୋର୍ସ ଡଟର ଇନକ୍ଲୁଡ ହେଲା.
sir
11 ରେ include
no,
ହେଲା.
actually what you are saying କେବେ ବି ପାଇବେ ନାହିଁ.
ନା ଡିଭୋର୍ସ
You are going to the extent that say ମାନେ she will never get that pension. That could be a possible interpretation.
Yeah.
But she has survived his she has survived her I mean father and mother both. Mother is not getting, mother ଯଦି ପାଇଥାନ୍ତେ ତାହେଲେ ତ 11 ରେ 18 ରେ ପାଇଥାନ୍ତେ.
ରାଇଟଟା ଆକ୍ରୁ କରିବେ ପ୍ରୋଭାଇଡେଡ୍ ହି ଇଜ ଏ ଡିପେଣ୍ଡେଣ୍ଟ ଡ୍ୟୁରିଂ ଦ ଲାଇଫ ଟାଇମ୍ ଅଫ ଦ ଏମ୍ପ୍ଲୟି.
ନାଇଁ 11 ସର୍କୁଲାର ତ ସେ ଅଲଗା ଅଛି.
11 circular ଟା ଦେଖନ୍ତୁ.
ଠିକ ଅଛି ଆପଣ ସେଟା ଦବାର ଥିଲା. Yes, Mr. Patra.
Rule 80B of the pension rule, let us kindly see. But the
ସେଣ୍ଟ୍ରାଲ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ର ତ କହୁଛନ୍ତି
Circular ଟା ଅଛି ନା.
our state rule.
ଷ୍ଟେଟ ରୁଲ 80B.
That is amended.
ସେ କହୁଛନ୍ତି 23 ରେ ଆମେଣ୍ଡ ହେଇଛି.
23/7/2011 ରେ
So ଆମେ ସେଟା ଡିସ୍କସନ କରୁନେ. So that point is well
they
taken.
are entitled 23/7 on the basis of the circular issued by the state government on 23/7/2011. Divorce.
See, here is a peculiar situation. 2011 there was a circular. Mr. Sahu's case is that she would get as per 2011 circular in 2022. But 2022 her entitlement was not decided. 23 comes another circular which disentitles her.
No, that is not dispute here. He has to prove, he has to dependent on the pensioner only.
Are 22 re when she is become a divorcee, for a divorcee nothing beyond is necessary to prove. Once she is a divorcee, because divorcee then otherwise how one will predicate the death of her husband?
She got divorce after death of pensioner. That's why he is not entitled. After death of the pensioner, she divorce else he is not entitled.
That is the point.
से डिपेंडेंसी टा प्रूव करिया दरकार पेंशनर ऊपर से डिपेंड करू
11 रे कोन थिला 11 रे कोन तो देखियो
23/7/2011
चल देखि दियो
23/7/2011
मिस्टर अपीयरेंस लिख ले. मिस्टर सुधीर पात्र फॉर ओपी नंबर 4. आपण कोटा मिस्टर साहू रिले
2011 circular.
हां जे को पैराग्राफ
ମୋ ପାଖରେ କପି ଗୋଟେ କପି ଅଛି ତ
ସେଇ ତ ପ୍ରୋବ୍ଲେମ.
ଏବେ ପ୍ରିଣ୍ଟ କରିକି ଆଣିଲି ସେ.
that is not mentioned in the 23/2011 circular. That is only mentioned in the rule 80 that is amended after 23/2011.
second page ରେ ଅଛି.
ये अनुसार से पाइबे. यस or like appearance लिख ले. Hard on counsel for the petitioner. The petitioner, a widowed daughter of a pensioner, seeks direction for getting family pension in terms of the Odisha pension rules read with the relevant circulars, particularly the circular dated 23rd July 2011 and the subsequent amendments. It is submitted by the Learned Counsel for the petitioner the petitioner, though otherwise entitled, has been deprived of the benefit of family pension. Issue notice. Learned AG appears on behalf of opposite party 1, 2, and 3. Waives of notice and appears on advance notice and waives notice on behalf of OP 1, 2, and 3. Change करते हैं. So the learned AG appears on advance notice and waives of notice on behalf of opposite parties 1, 2, and 3. Mr. Sudhir Patra, learned standing counsel, appears on advance notice and waives notice on behalf of OP number 4. Let 3 extra copies be served on the learned AG and 1 extra copy on the learned standing counsel appearing for the OP number 4. How much time, Mr. Swain, per counter?
Coordinate bench already decided the matter.
Hmm?
One matter has been decided by the coordinate bench. Allowed the writ application.
नहीं आपण 2011 रे आपण जोटा कोचन सेटा नाही आपण कोचंती the date of entitlement is the date of death of the person. That is, it is not there.
That is not there on basis of a clarification issued by the finance department that has been.
आसु काउंटर दबा
Counter आसु आपण मानकर बर्तन रोल एथिरे.
काउंटर आसु अबे काइन
You play a role here because they cannot think like you. As far as law is concerned, I mean, it is not. It is. I mean, I am not praising in the sense because they are not trained also. Welfare statute ra kon applicability hobo. Subsequent clarification whether can clarify the statute itself or overturn the statute itself.
On that basis, that has been quashed. Clarification was quashed by the coordinate bench.
Upon the withdraw kare, that has to be a policy, not by a clarification. Upon withdraw kar diyantu, pura withdraw kar dele, se challenge hobo. That's a different thing. But how do you determine that dependency? Because no one knows when somebody will die and she becomes a widow.
Here in the present case, what happened? He says that since 10 years back, from the date of divorce, he was residing with the father. Therefore, he is dependent.
Sheda se kohibe kahinki na anticipating this kind of argument.
In order to prove that he was dependent.
That he was dependent.
Yes.
But upon the divorce ପାଇଁ କରିଛନ୍ତି ଯେତେବେଳେ divorce or widow କେତେବେଳେ ହବ? ତା ମାନେ କଣ ଜଣେ pension ପାଇବେ ବୋଲି widow ହେଇଯିବ କି?
But the rule.
Widow is a unpredictable eventuality.
ଯେପର୍ଯ୍ୟନ୍ତ he is a dependent of the husband.
ତେଣୁ ସେଥିପାଇଁ ବି କରିଛନ୍ତି କାହିଁକି ନା ଯେପର୍ଯ୍ୟନ୍ତ ସେ married ଅଛନ୍ତି ଏବଂ ମାନେ not divorced otherwise ସେ ରହିଲେ ତାଙ୍କ benefit ପାଇଲେ.
Right to get the pension accrues during the lifetime of the person employee.
ତାଙ୍କ husband ଯଦି ଚାକିରି କରିଥିବେ daughterଙ୍କର husband ଚାକିରି କରିଥିଲେ କଣ ସେ pension ପାଇବେନି? Payment pension ପାଇବେ. Obviously ଏଇଟା ଗୋଟେ କରାହେଇଛି because when there is nothing for her, neither ସେ pension ପାଉଛନ୍ତି କି ଆପଣ ଧରନ୍ତୁ ବିଧବା ଭତ୍ତା ଯେ government ହିସାବରେ ପାଉଥିବେ, that's another thing. Otherwise she is primarily dependent on her husband. କଣ ଲେଖିଲେ? The learned counsel for the opposite parties pray for 4 weeks time to file counter. Counter will be filed upon serving copy of the same on the learned counsel for the petitioner. Stop. The petitioner shall have the liberty to file rejoinder. List after list after pleadings are complete. Liberty to mention for listing before the assigned bench. Yes, please. Next.
Item 9.
Yes, please.
Here,
Mr.
There
Biren
is
Shankar
short-
Tripathi
very-
for the petitioner, Mr. Sanjeev Swain, AGA for the state. Yes, please.
my lord, for very short point for consideration by your lordships, that after retirement, recovery cannot be made. This is the only point I urge before my lord, because Honorable Supreme Court of India, in case of State of Punjab and others versus Rafiq Machine, yes, 2014 for SCC base
The
334.
poro decision ta important.
My lord,
तार रफिक मसीर पर डिसीजन टा
my lord.
इम्पोर्टेंट.
But I
ये
have
कौन चाकरी करथिले?
piano.
पियोन ताले रफिक मसी. कारण ता पर डिसीजन टा आपण पे भी बहुत इम्पोर्टेंट. रफिक मसीर देयर इज
I will go through it.
नहीं आई
This is the case. हाँ
24 रे आ गोटे को रिट्रेट रे लागि जाईची
आज्ञा
से कोन 19000 आपण लिखचंती से
हाँ,
आ
हाँ,
गोटे
से-
रीड करियर
सेटा
दिले
देखिके
बदे
आउ बेसी मु कहली
आधे लगे देले आ
however notice has
मु भी
been
जतने किछि कहलिनी
आज्ञा
आपण कहले मु सुनिली
आज्ञा
आउ
that I know
सेटा आ गोटे रीट आनंतु तार निस्तार नाही तार जो 82000 टंका तार रिकवरी हेची
हाँ जो
से आ
जनरल
कोर्ट दौड़ी दौड़ी
सेटा जो जनरल एडवांस टा 19000
काली गोटे आपण से शेयर करछि बीइंग ए सीनियर मेंबर ऑफ बार काली जणे रिप्रेजेंटेशन डिस्पोजल तांकर हेतिला 44 वर्ष बयस हेतिला 2009 रे ट्रिब्यूनल ऑर्डर देथिले से रिटायर करी गले मिस्टर एसएन नायक काली के आर्गुमेंट कले से रिटायर करी गले ना होई परियोनी 15 वर्ष ला तांकर रिप्रेजेंटेशन डिस्पोजल होछि 3-4 थर रीट ओए रीट अपील बट आपण को किंतु रिप्रेजेंटेशन दवार थिला because now whatever they will say
otherwise on the light of that decision also your lordship can add only one line
so
they can reconsider my case again
लाइट मांडामस पकेले असुविधा हो काई ना आपनकर सेथिरे जो लाइट पडिची से होची वासर आपनकर डायरिस्ट
हाँ ठीक
and if you follow justice दीपक मिश्र judgment which is well reasoned they have differed with traffic message एई जिंसटा कोन आपनकर त एडवांस नै चंती हाउ कैन a court will say जे ऑडिट माने एरिया हाउस रे न हबनी बोली so for that there has to be a specific adjudication my limited understanding is that unless there is a determination by the authority it is for difficult for anyone to
so I
defend it.
So what I pray, your lordship may direct for reconsideration the matter and dispose of the writ application. That will be better. They will file counter is a retired person again.
Counter file kala pare
Reconsideration, sir,
Yes.
gote case re.
that is what I wanted to tell you. So I was not telling in so many words. When they file a counter, they will justify everything. 1, 2, 3, 4, 5 and try to get a order of the stamp of authority from the court.
My lord.
जे आमे जा करछु ठीक करछु.
आया ठीक है
So before that, at least they should say that हाँ इटा हमारे इतरे. But for that, this person needs some capacity to represent.
my lord.
सी जेमति जदि आपण 24 रे देबे पेज 24 रे जा रिप्रेजेंटेशन ता तो किछ बुझा पडोनी. He has to represent to the authority that for this reason I am not supposed to pay 54,000, 9,000
Yes,
and that 19,000. से आपणकर जोटा ओडिया जोटा अनेक्सर देइचंदी पेज
आया.
24
आया.
that only refers to paragraph 3
Three.
general advance 19,000.
General advance 19,000. हाँ सेटा
कौन लिखे? सेटा आउ नोटिस करबेनी कहउचंदी
ना
ना आपण इंस्ट्रक्शन आनिबे
फ्रेश रिप्रेजेंटेशन दियंतु दैट मे बी
हाँ सेटा एक्चुअली nobody knows what they want to
Yes.
say. That is the whole problem. You cannot challenge it predicate. कौन लिखले? नोटिस काटी दियो.
तारी भीतर टे sympathetic consideration आज के
आज्ञा.
retired person.
ता पूर्व लाइन टा कौन लिखथिले? नोट. Apart from making a representation dated 29/10/2024 regarding the general advance of rupees 19,000,000 into bracket annexer 7. It is submitted that the said representation regarding deduction of general advance of rupees 19,000 disputed by the petitioner is still pending disposal with the authority. Para. The learned counsel for the petitioner submits that the petitioner having retired is in no position to run after the petitioner since has retired is facing immense difficulty due to the deductions made from his retirement dues, which is as such a paltry sum. It is submitted that the petitioner shall move the authority for reconciling the deductions total amounting to rupees 85,321. Which may be considered by the authority, and appropriate decision should be taken. The Learned AGA, in response, submits that since the matter is listed for the first time, he has no instructions regarding the grievance of the petitioner, but any representation that would be made shall be dealt with by the appropriate authority in accordance with law, and a decision shall be taken. Para, having heard the learned counsel for the petitioner and the Learned AGA, the writ petition is disposed of, directing that the petitioner shall file a detailed representation along with supporting documents within 4 weeks before the authority, justifying his claim that nothing was due from him to be deducted from the retirement dues of unutilized leave salary. Jaldi hai to kahibe. I'll slow down. After such representation is made by the petitioner along with certified copy of this order, the authorities shall do well to deal with the claim of the petitioner and take a decision within a period of 3 months thereafter. The decision of the authority shall be communicated to the petitioner within 2 weeks of such decision. The petitioner shall have the liberty to take any follow-up action as would be advised pursuant to such order of the authority. It would be apt to mention here that the petitioner has retired from government service and his case needs to be considered by the authority as expeditiously as possible. The petition stands disposed of accordingly.
My lord, preferably within a stipulated period.
3 months. But आपण देई परिबा दरकार.
हाँ मु कहिबी फोन करिया.
तांकर जहा माने सी बुझी के निजे ठीक रे कागज पत्र दवा दरकार जे सिस्टा को
सर से डिसीजन टा सुप्रीम कोर्ट कोर्ट करथिले.
दरकार नहीं.
My lord.
से आउथरे आसीबे नहीं आपण पक्को.
आगे. ना आउ नो आसिया भला. I pray to God he may not come.
Exactly. But for a 85,000 rupees he will be running around.
Yes.
Yes, please, next.
Item 10.
10 below, I prefer adjournment.
You are Mr. Ranjan, Mr. Dhala. Mr. P.K. Dhal for the petitioner, Mr. Sanjeev Swai, AGA for the state, Learned Counsel for the petitioner seeks accommodation. As prayed for, the matter stands adjourned with liberty to mention for listing before the assigned bench.
11.
11 है जो प्रफुल्ल महापात्र आप लिखिए 2 equal to 11 equal to 12 से जो 12 से
12.
13.
13.
On behalf of Mr. Amya Kumar Chatoi,
Mr. T.K. Sahoo on behalf of A.K. Chatoi for the petitioner, Mr. U.C. Behura. I'm sorry.
after vacation, my lord.
Yeah. डाकुची क्विकली गले सरीबो काहेकि आपण माने डाकिचन सिटी पर जिबा पई डाकिचन आपण से चा खाया को जिबा पई जल्दी सारे पड़े चा फा तयारी करिवे ना आपण कोन लिखले A.K. Chatoi for the petitioner, Mr. U.C. Behura, AGA for the state, Learned Counsel for the petitioner seeks for accommodation, same order.
14.
Prafullo Kumar Mahapatra.
15.
Mr. Tushar Kumar Misra for the petitioner, Mr. 15 was the state private copy nahi
private ne
देखि दउछ
एटा फेडरेशन
opposite party blank रखिबे Learned Counsel for the petitioner seeks accommodation as prayed for the matter stands adjourned with liberty to mention for listing before the assigned bench. आपन आपको मैटर अछि कि
16, 19 and 20 is the same, my lord. 16, 20, 20.
Take 1 second. ଆପଣ କୋଉଟା ଏବେ first mention
First
କଲେ?
13,
13 equal to 16.
16,
Then
19,
19,
20.
20. 13, 16, 19, 20. मतलब मिस्टर छाटोई थिले तो हाँ was there पळेले. Yes, next. आपण चिन्ह कले कोटा कोटा को डाकिले
16, 19, 20.
हाँ next 17 मिस्टर घड़े
17.
Short adjournment.
I'm sorry आपन नाटा
Rajiv Bihar Mishra.
Mr. R.B. Misra for the petitioner, Mr. Pati, A.K. Pati AC for the state, Learned Counsel for the petitioner, 6 accommodation. As prayed for, the matter stands adjourned with liberty to mention before the assigned bench.
Obligation.
Liberty to list, liberty for listing. So listing, yes.
18.
18, yes.
May pardon, on behalf of Mr. Amir Mahante, permission made to submit this matter. On
आपन
behalf-
पूरा नाटा वो भूली गली. I'm sorry.
Samina Shahin.
Samina Sahin, S. Sahin on behalf of A.K. Mahanti for the petitioner. Mr. A.K. Patti, AC for the state, same order. The petitioner 6 adjourned. Petitioner 6 accommodation. As
No,
prayed
on
for,
behalf-
the matter stands adjourned.
May I permit to submit this matter? On that only I am begging.
I'm so
permission.
sorry. Yes, please.
The petitioner gives that due to non-deduction of EPF dues by the executive engineer RWS and S division Qatar Edgar for the period of 1/3/2009 to 31/5/12, and his pension period was not been regularized on the ground that he has not worked continuously for the 10 years. The petitioner has drawn the attention of the opposite parties on several by giving several representation.
But again, as I have been discussing, you would have marked with Mr. Tripathi and Mr. Swain that whether you have authorities have taken a decision on this. Have you?
They have given several representation. May kindly see all the annexure 6, annexure 4, and annexure
Yes.
10.
Last one with June 2024, 21st June 2024, Annexure 6.
Yes.
Yes.
So my humble submission, may only my representation may kindly be considered. Okay?
Because
They're very
unless they take a decision, it becomes very difficult to challenge. Because what is so it will be disposed of.
kindly only permission may I will give him to represent. Consider my representation because I have already retired. I am a very poor person. So how will survive after
The
getting?
petitioner has had learned counsel for the petitioner. The petitioner is agreed by the non-consideration of his representation for grant of pensionary dues
For the period of
and other retirement benefits after he has retired from while working in the establishment of kaha pakhare kama korthile
RWS NS division. RWS NS division.
Thagada,
Again, sir.
in the establishment of OP number 4. It is submitted by the learned counsel for the petitioner that the petitioner is now aged 62 years and is facing immense hardship. It is further submitted that the EPF contribution for the petitioner by the employees, so like an EPF contribution, the share of EPF contribution of the petitioner attributable to the employee was not deducted from 1/3/2009 to 31/5/2012, for which the petitioner is suffering without any fault. The learned ASC in response submits that he has no, since the matter has been listed for the first time, he has no instructions, but the pending representation can be considered and disposed of in accordance with law by the appropriate authority. The learned counsel for the petitioner submits that the petitioner at present will be satisfied if his petitioner, if his representation is considered and disposed of with a rescind order in accordance with law by the appropriate authority. Having heard learned counsel for the petitioner and the learned ASC for the state, the writ petition stands disposed of, directing that the authorities shall consider and dispose of the appropriate authority karibe. Appropriate authority into bracket IES shall consider and dispose of the representation made by the petitioner in accordance with law, taking a sympathetic view, considering his superannuation, and take a decision as expeditiously as possible. Subpara, the authorities shall act on production of the certified copy of this order along with the copy of the representation into bracket small s, along with all supporting documents sought to be relied upon by the petitioner. The decision shall be taken as expeditiously as possible, preferably within a period of 3 months. The order that may be passed by the authority shall be communicated to the petitioner within 2 weeks of such decision. It would be apt to mention here that, apt to indicate that, it would be apt to indicate that the entitlements of the petitioner, if any, that would be decided by the authority shall be dispersed after a decision is taken in that regard. The petition stands disposed of.
May I pardon?
Please.
In page 5, the only typical mistake on behalf
First
of
para lekhuntu. First para.
in Joshi, in place of Joshi, that is would be
Ms. Sahin,
proceeding.
M.S.Sahoo seeks leave of the court to carry out correction
Only what? Joshi.
in
will be
body of
proceeding.
the in the petition at paragraph 5.
No, page 5, first para, that is public.
In page 5 of the petition. Then subpara.
Fourth line, first
The
page.
petition, the learned counsel is granted liberty to carry out correction of typographical error in paragraph 5 of the petition to be countersigned by the court master.
Blessed. And
Hey,
same,
kore debe?
again, sir.
Mr. Barik, no, I'm telling him.
Same item, same matters, item 20.
Yes. Again?
Item 21, same item. Party only different and retirement period only different, same matter.
ଆପଣ ଏଟା କରିଥିଲେ କେତେ ନମ୍ବର ଆଇଟମ 17?
18.
18.
Sorry, 18.
21.
18 ପରେ 21. 18 ଏଟା
Same,
21.
sir. Same department, same matter.
Establishment भी same.
Same, sir.
OP4.
OP4. All the representation are printed.
Yes.
Only direction may kindly be given to consider my representation. That's it.
Yes.
Only
Yes. Next, please.
period is different and same all the facts.
Yes.
Joining and retirement.
Yes.
Obliged.
22.
ପ୍ରଫୁଲ୍ଲ ମହାପାତ୍ର ପରା
21 SN Naik. 21 SN.
But see that.
ନାଇଁ ଆଚ୍ଛା ଆଚ୍ଛା ଠିକ ଅଛି ହଁ ଆପଣ 21 ଟାରେ appearance ଟା ଚେଞ୍ଜ କରିବାକୁ ପଡିବ 21 Ms. Sahin for on behalf of Amyo Kumar Mohanty ହେଲା Mr. SN Naik AC for state टू हेले प्रफुल्ल कुमार महापात्र सकाळ जो फास्ट जो डाकथिले 23 Mr. Panigrahi
Lordships, similar matter, yesterday your Lordships was pleased to issue notice.
से item टा
Item number, yesterday item number 23 and 24.
23 and 24 to Mr. AK Panigrahi 23 25 ହେଲା yesterday item
23 and 24.
23 24 appearance लिखिबे Mr. AK Panigrahi for the petitioner Mr. SN Naik AC for the state. Yes, pass over.
Lordship.
Chala. Thank you. Wish all of you on Memorial Day and Happy New Year. God bless.